Tracy, this is Tracy, and I just wanted to make sure you could hear me.
Good morning. I can hear you just fine.
Oh, wonderful. Thank you.
right. Hey, Tracy, can you hear me?
We can.
Morning, I can hear you.
I just care about Tracy. That's the one I care about. Okay. We will go on the record with proceeding number 24F-0470T Larimer Emergency Telephone Authority versus Quest Corporation doing business as CenturyLink QC. Today's the 28th of April, 2025, approximately 11 a.m. This proceeding comes on for a pre-hearing conference, and I will start with entries of appearance. We'll start with complainant.
Good morning, Judge Garvey. Tracy Oldemeyer appearing on behalf of the complainant, Larimer Emergency Telephone Authority. And with me online is Kimberly Culp, the CEO of LEA.
All right. Hey, I'm going to ask real quickly. Tracy, does that sound okay? You're a little echoed, Ms. Oldemeyer.
I am.
Yeah,
I'll work on that while we're going through this.
you kind of sound like you're in a tunnel, but
Okay.
but I can hear, but I just want to make sure Tracy can. It's okay with her. Okay, for Quest.
Your Honor, Chuck Steese on behalf of Quest, and with me is co-counsel Rich Corbetta and client Adam Scher, and I see Tim Kunkelman has also joined, another client representative.
Hey, Mr. Steese, I got to ask you something real quickly here. As soon as I saw your name pop up there, I thought to myself, hey, Mr. Steese entered into this proceeding a couple months ago, and I forgot to look at your entry, so I pulled it up real quickly. Are you licensed in Colorado?
I am licensed in Colorado.
Okay.
I live in Colorado. I live in Arizona now, but I was there 25 years. So
okay. Like I said, I remember you were Arizona, and I pulled it up real quickly, and I didn't see a bar number for Colorado, so I just want to make sure of that real quickly.
yes, sir. If you want a bar number, it's 26924.
No, that's fine. I was just going to tell you to file a pro hac vice if you're not licensed in Colorado. But I remember when I saw that initially a couple months ago, and I saw the Arizona address, and I swear to God, 2 minutes ago, I thought to myself, gee, did he have a bar number or not? And I pulled it up and I didn't see it. So it got to the top of my sheet real quick. So all right, we have a bunch of motions and a bunch of other stuff here. First thing I'm just going to do, I'm going to start. If anyone has a problem with this, I'm going to start with the motion to compel. That was the first in time. We'll address that, and I'll probably make a rule. I intend, I can guarantee it, but my intention is to make a ruling on all these things, and we can move forward from that. You don't have to wait till the written decision comes out on it. Written decision will hopefully come out addressing all of these by the end of the week, but there's a few of them with the procedural schedule, and I don't want to. My administrative staff, I know, is already kind of pressed, but I don't want to keep this moving forward. So. The first thing I'll go to is the motion to compel then. And Ms. Oldemeyer, apparently from Quest's response, maybe some of these things have been taken care of, maybe they haven't. How does LEA stand on those comments in the response?
Well, first of all, Your Honor, can you hear me better?
It's a little better, but we can hear you. We can hear you. Like I said, it's just a small echo.
Okay. Well, with request for production number 4, which is the first issue we listed in our motion, we are still conferring with opposing counsel, but specifically what we're looking for would be an FCC certification, the support for that's required under 47 CFR 9.19. And then there's a subsection on records retention. The two components in particular would be network diversity, circuit diversity, and network monitoring. And as the court is aware from recent filings, we are looking for those from about October of 23, and they should relate to the green path, which is what CenturyLink has agreed or at least contends was in place, as well as now a temporary path is what it describes. And so those tests and monitoring would have taken place in that critical 519-day period, and they have not yet been produced. Those will be essential to the party's proper understanding of the issues in this case. So that is it on request for production number 4. Documents showing in fact what fiber circuits carried 911 traffic, and those particular documents that we've narrowed in on would be essential to that. If they don't exist, we believe CenturyLink needs to state they do not exist.
Well, let's just go one at a time on these. So where does CenturyLink stand on that? What Ms. Oldmeyer said.
Your Honor, briefly, in terms of saying whether they do or do not exist, the request for production was not focused on these individual documents. It was focused on a broad category of materials, and we produced those materials as we should. With respect to the specific question that Ms. Oldmeyer focused on, if you look at her own motion, page 8, the audit itself, once you get there, you audit facilities from the selective router to the last central office serving the PSAP. That is what you audit. And when you look at the last central office serving the PSAP, it is the Loveland Central Office. Estes Park CO is a remote switch that is hubbed off of the switch in Loveland. And so it is a functional piece of the Loveland switch. So whenever there is a remote switch hubbed off of a local end office switch, the last end office switch by rule is the one that the remote hubs off of. So she's looking for auditing between Loveland and Estes Park. And the auditing obligation does not extend to Estes because it is a remote switch.
Do the documents exist?
Because of that, there is no audit of those facilities, so there's nothing to produce.
Okay, and so that at least apparently would answer that question. If Ms. Oldmeyer is looking for a response of this exists or this doesn't exist, it does not exist. Correct? Everyone, Ms. Oldmeyer, does that work for you?
I think that resolves my issue. Yes, Your Honor.
Okay, good. And I think there was something about bait stamping. That's the other thing I had written down, at least on the response.
Your Honor, I do believe we worked through those issues. When I asked specifically to point me to the document that they're saying is responsive, I got it's in there. I'm good.
Okay, yeah, no, that I gotta say that I was in my looking at the case law on that, it seemed to be only related to if like it sounded like parties were taking a bunch of documents, throwing them up in the air, and then taking a broom and putting them in a box and going, here you go. And so as long as they weren't doing that, they were okay. So
right.
Okay.
Well, and Your Honor, this particular answer that there are no documents, nothing to produce is helpful to me because that's very different than it's in there. It's in the 2,300 pages we gave you.
Okay, great. Okay, let's go to RFP 5. How do we stand on that, Ms. Oldmeyer?
Your Honor, I also believe that request for production number 5, I am currently satisfied with. If there's an explanation, there is no engineering drawing or design drawing of the temporary path.
Yeah, okay. That's the way I saw the response saying that. And again, then I saw a minor thing on the Bates issue. So so we can put that down as resolved?
I believe for the time being, yes, Your Honor.
Okay. Then we got 12 and 13. How do you stand on those, Ms. Oldmeyer?
Your Honor, I think with the information that I've obtained, I do not think responsive documents have been produced, but I'm comfortable with the information that I have in email exchanges, combined with depositions of the key people that have subsequently been identified, the names of the technicians who we would like to depose, that I can get down to the information that I need versus you're asking for too much information and it's just too burdensome for us to go find the documents. I'll narrow down what the witness is on exactly what I'm looking for from them and their participation on particular dates.
Okay, so no problem with 12 and 13, just making sure.
For the time being, Your Honor, that would be correct.
Okay. That leaves interrogatories 9, 10, and 12, which kind of all are the same. I'll comment real quickly. Is this only on the names being confidential? Is that still what it is? I'll say first off, right now, when I read that, I think it's a little premature to be confidential on that. These aren't in public right now. It's a discovery response, so I'm not quite sure what would happen, but I mean, they would come out anyway. If they're witnesses, I mean, we're not going to have them behind a window and with the garbled voice, so they're going to have to testify. So at least for this point, I don't see that they would be confidential. I mean, Mr. Steves, I'll let you say what you want to on that, but you're going to have to help me with that.
The only thing I think you addressed the point that I was trying to make. It's not even clear they're witnesses yet. These technicians themselves, several of them, there's a question about whether they'll be deposed. We'll deal with that in a moment. But I don't think a single one of them is going to have anything that is material or responsive to the case at all. And so the fact that if they become witnesses, of course, then they're witnesses and they testify live. But until they're actually a witness, technicians are, I would always protect their names. And if they become witness, they become a witness. And then it's in the public. So
yeah, at least
that it's not confidential, of course, then we'll treat it that way. But
okay.
I would always err on the side of protecting the confidentiality of the witness's name until they're a witness.
Yeah, like I said, I think it's not quite right yet because it's still in discovery. So I don't know what is going to happen with the names, but we can worry about that later. Is that okay with everybody? Ms. Oldemar, does that work for you?
Certainly, we'll serve deposition notices with those names in it. And if that becomes part of a motion for a protective order again, we'll have to address it at that time.
Correct. I agree. Okay. So, and just double checking here, I'm thinking the motion to compel we've got through. There's nothing left. There's nothing to compel at this point, correct, Ms. Oldemar?
Well, Your Honor, I think the statement on page 7 of the response that CenturyLink has confirmed that there are no responsive text exchanges between the known technicians. I'm taking that at face value and I will explore it further as to whether they existed at one point in time and no longer exist. That's going to be a critical area of discovery that we're going to go down. But again, so for purposes of resolving the issues today, you know, we don't want to prejudice ourselves from coming forward if we learn things are different.
No, certainly not. Certainly not. Yeah, I'm just worried about today.
Okay.
I have to issue out an order on here, and if there's nothing to compel, there's nothing to compel at this point. So, but yeah, certainly you can bring up any of these. If they say that doesn't exist, that's certainly something to ask any witness out there. But okay, we'll move on from that. The next one I have is the protective order. And I'll ask CenturyLink on this. When I first read this seemed to be something more of to the effect of, let's wait and see how discovery turns out and whether this is necessary to depose these people are necessary. Is it your opinion that that's the case still? Has discovery rectified the need?
Your Honor, you summarized it pretty well. I think that it was twofold. And one is it was premature. And it's certainly not premature now to talk about depositions. It seems like it's the right time to talk about depositions. But Ms. Oldmeyer served us with 4 deposition notices and has told us she's going to serve 3 more. So 7 depositions is of all of CenturyLink employees is a lot of depositions. Well more than would be permitted under the presumptive rules. And I understand they're the presumptive rules in civil court. And so in our last meet and confer, when Ms. Oldmeyer and I were talking, we just want to understand what the scope of deposition discovery how much will be permitted. Is it just going to be however many notices you can serve? I've never seen a case in federal court or anywhere else where you just have an unlimited number of depositions that you can take. It's You focus yourself on what really needs to be taken and not just because someone's name pops up. Example, Mr. Trupp and Mr. Calzolari are two people that have already been noticed for deposition. And if you look at what's at issue in this case, what is at issue in this case is really three things. One is there is a Colorado rule that says CenturyLink must provide geographic and physical diversity to the extent feasible. One. Two is, did CenturyLink violate its tariff? And the tariff provision states that as of September of 2018, CenturyLink had diverse facilities in place. And if there is a request for additional diversity, here's the process you go. And the third is whether or not CenturyLink falsified various compliance filings with the commission. Nothing about whether or not Mr. Trupp or Mr. Calzolari were aware of whether or not PRPA, we have leased facilities from PRPA because they're looking at our own facilities and they're not seeing the leased facilities. Why is that relevant? It's not. It has nothing to do with whether or not any of the rule or the tariff were violated. Similarly, whether or not a technician goes to a particular location and has the correct tool to perform work, there's really nothing that goes to any of the issues in the case there either. So when you're talking about deposition discovery, it appears as though the focus isn't on the claims and the discovery isn't focused on the claims, but the discovery is focused on trying to embarrass CenturyLink in some way. And if we look at the various allegations Lead has made very respectfully, we think that they're wrong on many facts. But to me, why do we have to fight about facts that have no bearing at all on any of the claims that are at issue? And so this is the reason why deposition discovery is normally focused. Because instead of going after extraneous information, you try and focus on what your claims are about. So we're looking at this and we're thinking how much deposition discovery is needed. We wonder if any is, but very respectfully, if there's going to be some, we think that Your Honor should set a number of depositions. And this is the maximum number each side can take. And whatever Your Honor decides in this regard, of course, we'll comply with, but that's the second piece of what we think this motion for protective order is about.
Ms. Oldmeyer?
Your Honor, I think our response was pretty thorough on what the law provides and the rules of civil procedure provide, which are, we are entitled to conduct the discovery that we choose in the order that we choose. And it's not intended to embarrass CenturyLink. It's not intended to go on a fishing expedition. We have real disputes about concrete facts of what occurred at least between 520-day period of February. I don't want to violate confidentiality, but 520 days, and who did what and when, and who knew who did what and when. And we have information that CenturyLink has provided that absolutely conflicts with some of the positions they've taken early on in this case. And just because they're educating themselves, because we're asking more pointed questions and having real candid conversations between counsel, doesn't mean we're not entitled to gather the evidence, to present the evidence at this hearing, because, you know, Your Honor, you're to decide those disputed facts. And what we have now is an admission, despite what their characterization of our claims are, that there was a lack of geographic and physical diversity, at least in one section, for a 529-day period. That is critically important. And with respect to the witnesses we choose to depose, they should not be limited in number or, you know, and again, we offered 2-hour blocks for the 4 witnesses we initially noticed, except Mr. Kunkelman, who's a director, regional, I think it's a regional vice president, who verified at that point in time in January the answers to interrogatories. So we've got more time with Mr. Kunkelman, but the technicians will also be very short and direct and focused on the work they did. CenturyLink's position that PRPA did a lot of work unilaterally is inaccurate now, and we want to know what the work these technicians did and why. And it's directly relevant to the claims and the disputed facts.
Okay, Mr. Stevens, it sounds more like your problem is not with these people being deposed, it's more with the questions they're going to be asked. And I can't, we're not into the case yet at that point. So as long as, if these people have some relevant information, I can't see that they wouldn't be deposed. I will say that during my 2-year leave from the commission, when I was working for the federal government, when I would do pre-hearing conferences like this, we did limit the number of depositions. That was not a foreign thing. In this world, I don't ever hear about depositions too much here. They don't come up very often. They certainly don't come up in this regard. So it's kind of something unusual to be here. Ms. Olmer, how many people do you think you would have to depose just right now? I'm not going to hold you to it. Just what do you think?
All right. We would still like the 4 initially noticed depositions. That would be Christina Rangel, I think is how you pronounce her name, Dan Trupp, Gary Colazari, Tim Kunkelman, and then they identified 3 technicians in addition to Christina Rangel who worked remotely. And so I don't want to say their names because they're designated confidential, but those 3 individuals. We have an issue that council and I are going to be working through with an individual named Barry Fox and his role. But those are the ones I've identified. And we may choose not to take all of them depending on how things shake out in the depositions, but those are the ones at a minimum I have identified.
Okay, so that's at least 7, potentially 8.
Correct.
And Your Honor, briefly, it
Sure.
isn't questions that are going to be asked. That's not the point. The point is, if you have a fixed number.
Mr. Stees, I'm having a little bit of trouble
Yeah.
hearing you. Can you speak up, please?
Is she speaking to me?
Yes, yeah. I think you moved back and moved away from your microphone.
Okay, that's fine. I'll speak up. I apologize. It's not the questions they're going to be asked. It's the number of depositions. If you have a focused number of depositions, then the opposing counsel tends to focus on the things that matter more directly to the case. And so, for example, Mr. Calzolari literally knows nothing. He knows nothing. He went to these meetings, a couple of meetings during the middle of the fire, and his responsibility isn't even this area. And so he was there as someone trying to assist in the middle of a fire. And so normally depositions help counsel focus on what really matters. And if you give them an unlimited number, then they go on what amounts to fishing expeditions, which is what we're saying is create a maximum number of depositions that can be taken, which will force counsel on both sides to be focused. That's all we're saying.
Okay, no, that's what I'm trying. That's where I think I'm ending up. But I'm just trying to make sure. If someone has relevant information, I believe the party has. They have a right to go to that deposition if they think there's something there. You find that and they go, listen. The deposition is the question, and the answer is I have no idea every time. That's Ms. Oldemar's money down the drain. So, but I tell you what, why don't we say 9, Ms. Oldemar? I'll give you one more on top of that, just in case someone pops up that you see later.
Thank you, Your
Does
Honor.
that work?
Yeah.
So limit to 9. Like I say, when I did my federal work, normally I did about 5. I did, in some cases, I actually did 10 depositions. It was limited to. So I'm going to say 9. So the protective order is going to be denied. Because again, I didn't hear anything about the witnesses themselves that said they shouldn't be deposed, but we'll limit all depositions. We'll limit both sides to 9 depositions.
And so just to make sure I understand, CenturyLink will also have a chance to take depositions too, correct?
Absolutely, absolutely, up to 9. Up to 9. And if you find that you need more for some reason and you want to file a motion because you believe that should be, I will certainly entertain any motion. I certainly think in depositions, like I say, Ms. Odemeyer has brought up stuff where CenturyLink's answer has been, we don't have that. Well, maybe a deposition brings up an answer that maybe something like that exists. Some other person might have it. They might not be aware of it at this point. So at least till now, I'm not saying I'll grant it, but I'll entertain it at least. Okay. Anything more in a protective order on either side? No? Okay. That leaves the amended answer. I'll just, oh, well, Ms. Odemeyer, I'll let you, I'll let both parties speak real quickly if they want to on this one. Ms. Odemeyer, I'm going to let you go first on here.
It's our motion, the motion.
Yeah, it's her motion. I'm just curious what the reason for not wanting it. I just got the part it was confidential, and that seemed to be a big part of the problem. But if Mr. Teese, if you want to go first, you can. That's fine. I'll let you do that.
I was just going to say a couple of just brief comments. We filed our initial answer on December the 11th of 2024. On December the 17th, just 6 days later, Your Honor stayed the pre-hearing conference that was supposed to be scheduled for January 13th. And then we had this stay until April 4th. And the amended answer was filed 4/8, which is basically almost 3 weeks before today, just not 1 day less. So the case is just getting started, and our answer conforms to the amended answer conforms to the facts that will be presented at the actual hearing. And so, and it conforms with our interrogatory responses. And so from our perspective, it's important to make sure that the answer accurately reflects the information that CenturyLink has in its possession, which the amended answer does. That's all I had, Joey.
Okay. So, where'd you go?
Sorry about that, Your Honor.
It's all right.
I tried to mute myself, and apparently I turned off my camera at the same time.
All right, go ahead. You can go ahead. Hopefully you're able to hear Mr. Stees.
Yeah, and I mean, Your Honor, I think our response really put forth all of our arguments. We have compared via red line, the substantive changes. CenturyLink did have the information it has now. This is not based on new information. And there's no basis in the law to file a confidential or partially confidential answer. The facts are what the facts are, and they can choose what they put. They can word it so it's not confidential, but the fact that they're trying to change their story now and admit, yes, there was a temporary path in place, and yes, for at least an 8.5 mile segment, it lacked geographic diversity. And we're going to still argue over other issues about whether there were two lit circuits and all of that, but I'm not sure the law permits what they want, which is a confidential amended answer. And then number two, we do think there has to be a showing of good faith and a lack of prejudice. And we filed direct testimony already that contradicts statements, the very few statements that were in the initial answer that they now want to back away from. And they should be held to the statements they made in their original answer. And we disagree with Mr. Steese about the timing. So again, this is before his involvement, but what the court did was vacate the pre-hearing conference that was set for January 13th. There was never a stay in the case, and the parties were doing discovery in the months of December and January until the judge issued the stay, which I believe was January 30th of 2025. So there was a lot happening, and I don't know what the confusion is there, but CenturyLink had the information, had requests for it to look at information that Lita wanted, and never chose to file then for leave to file an amended answer. We are going to use answers to interrogatories, etc., as evidence at the hearing. But it doesn't need to be in an amended answer. And they can make whatever arguments they want in discovery or orally or with their own evidence. But an amended answer at this point in stage, it doesn't, A, the law doesn't support confidential, B, there's no good cause, and C, we argued the prejudice to Lita.
Let me ask you something, Mr. Steves, real quickly. I didn't do a side-by-side comparison all the way through. I think I looked at paragraph 93 and I saw paragraph 93 look the same or something like that. Is there anything other than that opening? Nothing changes in the numbered paragraphs. Is that correct?
That's not correct.
No.
There are, many of the paragraphs are exactly the same, Your Honor, but not all of them are exactly the same. I don't suggest they are. The point that I was trying to make is a scheduling conference, as we're sitting here for this pre-hearing, this is the beginning of the case. We provided the supplemental interrogatory responses on March the 5th, which was more than a month before they were, not more than a month, almost exactly a month before they filed their pre-filed testimony. So the fact that they had this for a month before they submitted their testimony is absolutely true. That there is no prejudice whatsoever to Lita. That doesn't make even any sense at all. In terms of their testimony that they submitted, their testimony ignores the March 5 interrogatory responses. It attaches the earlier one. And so you can't ignore the facts that CenturyLink is going to be presenting at the hearing. If you do, it's at your peril. And so there's no prejudice. And I didn't say that there was a stay that was in place. I said that the pre-hearing conference was reset. And that's what normally kicks off a case, and the amended answer came almost 3 weeks before. So the simple fact is the case generally proceeds from the pre-hearing conference, and they had the amended answer weeks before. So we should just link this. In terms of confidentiality, Mr. Scher and I had a case in Washington on 911. And there, the public agencies thought everything was confidential because knowing the location of individual circuits, if someone were to want to do something malicious, heaven forbid, and they get information from this and they're able to use that to do bad acts, that's exactly why we filed the details about the locations of circuits as confidential. That's a standard thing you do with 911. It's a public safety concern. That's the reason why we focused on the route locations as being confidential, and the only reason. And way more than that was mandated to be identified as confidential in a 911 case that Mr. Scher and I recently had in Washington.
Okay, first up, I'll hit. I agree. This is early in the case, and it's obviously had a tortured beginning to just get started. So we're finally here, and I think we're still early in the case. I don't think there's any prejudice yet, and basically, I think some of the things actually kind of admissions by CenturyLink too, and would almost be helpful. I spoke with I was speaking to my advisors last week about this, and one of my advisors brought up, Mr. Steves, that very point about the circuits and how they could be out there, and potentially that could be a general danger if someone was to use them for some nefarious purposes. And it was brought to me that better to err on the side of safety on that point. Your lead is able to get that. It doesn't make sense to put that out there.
Your Honor, if I could briefly respond.
Let me finish talking and then I'll let you respond. Okay. So I'm going to allow the amended answer. I think like I said, I think we're still early. I don't see very much prejudice. I also find it should be confidential there. Again, I don't want to let that go and something happen. I don't want to be the one who's responsible for that. So, okay. Ms. Oldmeyer, go ahead.
Other than the temporary path, which again is information that was late disclosed by CenturyLink, The green path and the purple path, they described in detail in their public filings in the iDocket going all the way back to 2013. It's mostly the 2017, 18, 19 filings. It's out there, it's in public, and this is no different. And they're not identifying specific circuits, they're not identifying addresses. It's a general description of the path. And the prejudice is it makes it very difficult to present evidence in a public hearing when we are redacting exhibits or having confidential testimony about an exhibit that they've marked confidential. So I just want to note for the record that we disagree that this information is confidential or should be deemed confidential. It is not detailed enough. And then number two, we don't believe this case is at its infancy. We knew early on our information had to come from sources other than CenturyLink. And we did our legwork, and we have gathered our information, and we have filed our information. Now that CenturyLink's tune is changing because of the fact that we have confirmed with third parties certain facts, doesn't mean this case is at its infancy because CenturyLink is just finally getting going. Lita, the complainant, is ready, needs the discovery it seeks, and wants a prompt hearing on this really important issue affecting public safety as we approach fire season here in northern Colorado. And this is a repeat issue about lack of diversity for Estes Park. And so we would emphasize those points, Your Honor.
Okay. That's great. Like I say, and speaking to my advisors, I think the wise course of action is to keep that confidential. All right, that leaves, so the minute answer will be granted and will remain confidential, that part. That leaves the schedule left. And Ms. Odemeyer, I will tell you that when you sent your email, I had seconds earlier said, hey guys, how about we have this hearing either the week of July 28th or the next week. So I said that, and boom, all of a sudden came an email with you suggesting that date. And I'll tell CenturyLink, because this pre-filed testimony was filed, that started the clock on the case, and that schedule can't work. That you have, unless Lita, and I will be very shocked if Lita wants to waive the clock on this one. I'd be surprised. So it goes to the preferred and the alternate.
Can I be heard on that particular point?
You sure can.
I hear what you're saying, and I respectfully disagree, because there's going to be depositions that they're taking. They plan to take them the first week of June. They want to supplement their testimony with the testimony of the deposition testimony. They want to use that at the hearing, which is the creation of new testimony that starts the clock afresh. In addition, they have deposition that they want to take depositions the first week of June. That's the entire week they've set aside. And at least one of the people, I haven't confirmed whether others are available or not, but Mr. Kunkelman is not available for deposition that week. He's on vacation. And so in order to take up to 9 depositions between now and the hearing and give us, because we have a statutory right to respond, literally a statutory right in commission proceedings, to the extent that they're using testimony, we have a right to respond in kind. And so if you look at that deposition testimony, that is going to impact the schedule. Lastly, with respect to PRPA, we served them with a subpoena, and we have been working with them for weeks, and they can't get us the material until the earliest on May the 2nd. In addition, we likely are going to serve a subpoena, depending on what PRPA gets us, on a government agency called WAPA, Western Area Power Alliance. And so to get all of this done effectively in 2.5 months is an extraordinary amount, especially when the case was stayed without question for 2.5 months while an issue was being resolved. So if we look even if we're going to keep an accelerated schedule, my request would be that we do it at least 2 weeks later in August to give us a little bit more time, given that the circumstances there.
Mr. Steves, I got to tell you, I could not disagree and agree with you more. Some of the points you made, I totally agree with, and some I totally disagree with. The unfortunate problem here is that testimony got filed. Okay, at least on my end, that started my clock, and my clock that started the commission's clock, and so the commission decision right now, and that's on exceptions, must be out by Halloween. I can't do anything about that unless it is that timeline is waived by LEDA, and again, I don't think that's going to happen. Many of the things you said may not be possible. But then again, the party that's bringing this case has to do that. That testimony was filed. So that's all the direct testimony we're having from LEDA. They filed it. It's done. It's over. Next is up to you. So I don't know what the
testimony is locked in stone. No more testimony for their case in chief.
Not direct. Absolutely not. They're done. They filed the testimony. So there's not going to be any new direct testimony at all. Can't. Honestly, I can't. With the schedule, I can't. Unless if there's a motion made and there's a waiver, potentially, if there's good cause for that, but that started the clock, and I'm stuck by that clock.
So what if they want to use deposition testimony as rebuttal? Rebuttal to what? Because we won't even have, by the time the deposition testimony is completed, when are we supposed to file our testimony? Because we definitely need PRPA's deposition in advance of filing our responsive testimony.
Not to tell you how to do your job, Mr. Steves, but I would read that rebuttal testimony and I'd find whether you'd move to strike any of it. You never know. If it goes beyond that, that could be something that could be. I have had motions in limine. I've had motions to strike before on rebuttal testimony. So, that could be something that's thought of. But so one thing I will say for CenturyLink, I do think the May 23rd deadline for answer testimony is a little quick, especially since LEDA wants to give itself until July 9th for rebuttal testimony, which seems pretty unfair. So the June 18th that's on the alternative is where I would put CenturyLink's answer testimony. CenturyLink have any problem with that?
Your Honor, can we move 1 week beyond that?
Let's see. How long does that give? Let me just take a look. Okay. June 18th would move to 25th would give I tell you what. Michelle DeMar, how if we move how about if we move LEDA's rebuttal testimony is currently on a Wednesday. I'll give you one more week if we move July 11th to rebuttal testimony. How about that?
When would answer testimony be due, Your Honor?
Answer testimony would then be due on the 25th. And then I would make, why don't I tell you what, I'll do even one better than that. I'll make it due the 14th, July 14th. So I just think that's a quick turnaround. And one of the other things I tell you, if you have a settlement in this case, I don't need to approve it. So you don't need any settlement testimony. Don't worry about that. In complaint cases, I'll tell you just my experience with complaint cases. First off, I rarely have pre-file testimony. That's not 80% of the complaint cases are somebody who thinks their bill was wrong from public service. So I don't want pre-file testimony from pro se parties. So it doesn't happen very often, but it's between you two parties. I don't have to approve your settlement. I don't want any settlement testimony. All that happens at that point is you withdraw the complaint when the case goes away. and I'm going to ask you, Ms. Oldemire, when you have witness lists and witness and hearing exhibits and exhibit lists, are you not intending on thinking you're calling people who are not, that you don't have pre-filed testimony from? Is that correct?
It may be that I choose to call Mr. Kunkelman or another CenturyLink officer if they're not going to. And so Mr. Steves and I are still working through who our CenturyLink's witness is going to be and that. So
Wait, see, either we have pre-filed testimony or we don't have pre-filed testimony. It's not, we don't move back and forth between the two. So you have your witnesses and you have your direct witnesses and they're in there.
that
Okay?
is correct, Your Honor.
Because you chose to do that. You can have, and you'll have, if you have different ones for rebuttal, you can do that.
Correct.
But you can't on July 16th say, hey, I'm going to want to call someone live. That's not going to happen.
I will be working with counsel on the proper presentation, but in the proceedings that I've been involved in the commission, we do set dates for witness lists and exhibit lists, and we work together. And I'm not saying I'm trying to change our direct testimony, but I am not going to tie my hands to not agreeing to rebuttal testimony and who that might be and why as things unfold over the next few weeks.
Well, by the 16th, the rebuttal testimony ought to be in. That's what's confusing me, is because by that time you should know your rebuttal testimony is in, your direct testimony is in. Those are your witnesses. And CenturyLink will have their witnesses at that point. And that's that.
So if you don't want witness lists and you don't want the matrix and
no,
things,
the matrix is a different thing. Matrix is a different thing. That's why you have matrix down further. That's why I was confused by that. It just seemed to me you were trying to, like there was going to be live testimony that was going to come. There's some different witnesses that did not pre-file testimony. I certainly have not done that and don't want to start today either. Let's see. And again, just when you have the matrix there, you have order of estimated time for direct and cross. And I don't know if that's just for sake or whatever, but your direct testimony should be, here's my witness. He's ready for cross-examination. There shouldn't be any live direct testimony. So I don't want, that should just be cross. It's just cross time on the matrix. The evidence you're hearing, the one thing I'm going to change, I'm not quite sure we need 4 days. I looked a little bit, you have about 6 witnesses I saw. I looked at how much testimony they have, and I saw one had 4 pages of testimony, 2 had 11 pages of testimony. I just don't imagine there's going to be a whole lot of cross-examination on them. But I'll keep it at 4 days, but what I have to do, one of my advisors is actually going to be out of the office on the 31st of July. So if you don't mind, if it's okay, I want to make it the 28th, 29th, 30th, and then the 1st.
Of July?
Of July and August, yeah.
It's not possible to move that back a week or not? That's what I was trying to ask, Your Honor.
Okay.
Moving back into August. And I was thinking, because they had an alternative, which was August 12 through 15. And the question is, would those days work for Your Honor?
The 12th will not. Actually, I'm in a public service hearing that starts on the 11th. I could potentially move it to the 4th if the parties want that. Ms. Oldemire, I'd have to check with my advisors too on that real quick. Ms. Oldemire, how do you feel about that if we move back 1 week?
Your Honor, I apologize. I keep hitting my video versus mute. I have verified with the 7 witnesses that they will be available in person the week of July 28th through 31st, or alternatively August 12th through 15th. The week of August 4th does not work. I have 1 witness, July 28th through 31st, who would need to testify remotely. But these have been cleared with those witnesses for that very reason, the importance of them being present in person.
Yeah, I gotta say, and I can't do it the next week. So
Is the whole week off, Your Honor, or could we do if you see what I'm saying, where we just have a gap of the day. I'm not trying to press, but if there was.
It's if Ms. Odemeyer has it down here for 4 days, I know you have fewer, and I think it probably will be fewer than that. Technically, I'm in hearing for 2 days. Again, it's a public service hearing, and then I am off on the 15th. So I think it can very easily bleed into the 18th, which is really a lot later than I want, because that's not going to give me time. And I think we're stuck on the 28th, and it's going to be what it's going to be. Okay, and you have said hybrid, Ms. Oldmeyer. How does CenturyLink feel about hybrid, in-person, remote? What's their choices?
Our reaction is it should be a live hearing. If there's an individual witness, I think it's important for us to see who that witness is going to be. There might be a few witnesses who have small testimony or unidentified, that some of them are very small, have short testimony. If they wanted to testify via Zoom, I'm confident that we could work with Ms. Oldmeyer getting that done. But for the most part, we'd request a live hearing.
Ms. Oldmeyer, live or hybrid or remote? I think hybrid is what you want.
Our position again was hybrid because one witness must testify remotely. But our preference, as Mr. Stees indicated, I'm sorry, I'm answering the judge's question. As Mr. Stees indicated, our preference really is for in-person testimony. But because I've clarified with all witnesses about their availability, I just have that one exception where he will not be here in person.
Okay, Mr. Stees, come closer to your microphone, please.
And which witness is that?
That would be Under Sheriff Shellhammer.
There's no objection to that at all.
Okay, okay, we'll make it hybrid. I'll make it hybrid if parties decide otherwise. Tell me that just so I can. Excuse me. I have talked to my legal assistants and my court reporter and so forth, and so they want to know where to go. So at least a week beforehand, tell me that you decided not to do it that way. But we will be there. And then yeah, we can SOPs, the 13th is fine. So okay. Anything else on the schedule that I missed? I don't think so.
Your Honor,
Okay.
just to confirm, my understanding is we're going to have CenturyLink's answer testimony due June 25th.
Mhm.
The discovery will follow the discovery rules about discovery on cutoffs for answer testimony and rebuttal testimony.
Right.
Lita's rebuttal testimony will be due, did you say July 14th?
14th, right.
And then
And I'm not going to put anything on depositions. That's for you guys to figure out. Okay. You figure out when you want your depositions.
right. Thank you, Your Honor. And then the hearing will be the July 28th through the 30th.
Yeah, with 28th through the 30th, and then I'll put the first on there as well.
Okay.
I'm nothing without my advisors, so I want to make sure they're available the entire time. And one of them is teaching a class, if I recall correctly, that day.
Thank you, Your Honor. And then statements of position would be due August 13th.
Yeah, as of right now, I mean, potentially that might change based upon how the hearing goes. I'll entertain any motions to change that. If it gets more complicated or less complicated or whatever. But for right now, we'll say that.
Thank you, Your Honor.
I'm always kind of open on the statements of position because sometimes things happen in hearings that might require it to be a little more extensive or not. So, but I wouldn't expect to move too much because again, I would probably have to have that decision done within about 15 to 20 days after the 13th, just to make my deadlines. Okay. I think that's it. I think we covered everything. So, anything more from Lita?
Not at this time, Your Honor. Thank you.
All right, Mr. Steezy.
Honor, nothing more. Thank you for your time this morning.
All right, and like I say, you can move forward on that. Figure these things are out. I'll issue out a written decision, hopefully by by the end of the week, first of next week. I have a couple things going on, and I think my administrative staff is a little backed up, so it might take a couple days. But all right, I think that's it. I thank everyone for being here, and everyone have a great week. Thanks.
Thank you.